State of Kansas versus Owen Solomon. County Attorney Jill Gillette for the state. The defendant fails to appear. The defendant last hearing was a forfeiture on bond, July 12th, and that was 2024, and that was granted. This is the case where the defendant and his girlfriend are from the state of Washington, and he harvests salmon or something of the sort up there, and gave us his assurance he'd be back, but he didn't come back. And now we are here today because the bondsman has filed a motion to reconsider that judgment for July. And he has filed a written motion. Sir, do you want to state your name and proceed on your motion?
Yes, this is Tyson Case with Case Bell Bonds. Now if you recall, Mr. Solomon, you gave us until I believe it was a September date. We hired a out-of-state bounty hunter because I was going to go out there, but we were told by local officials that we were not allowed to bounty hunt out there. Washington State has a very strict bail reform laws, so we hired a bounty hunter. I had him in custody.
Okay, hang on. They will let you use their bounty hunter, but they won't let the Kansas one come in and do it?
Correct.
Okay, go ahead.
So we hired, and you gave us extra time, which we really appreciate. And I know how much of a stickler you are on this from dealing with you multiple times, Your Honor. So I did expedited, got him arrested. He was in custody. He is in custody still. In let me pull it up. It's on VineLink right now. He's been in custody since August 27th at 10:07 a.m. in Snohomish County Jail in Everett, Washington. So our deal was, so I got him in custody, and we've been navigating with your courts to get your process, because it's a little bit different than ours, and I'm learning your process more and more every time. So what we did, was they were about to release him because of they wouldn't put your guys' hold on him. That was the same.
Now we have, as I understand it, a felony warrant in NCIC, right, Ms. Gillette?
Yeah.
You say we do?
We do.
All right, so I don't understand why another state wouldn't recognize that. Do you have any idea why they were going to release him?
Well, because Washington State has kind of adopted the New York principle with bonding.
Which is what? I don't know what that is.
It's a bail reform deal where pretty much in them states you can almost do anything and get released. It's wild. It's just a Wild West type of operation. So what we did was, so he was arrested there prior to this, but your warrant they would not hold him on your warrant, so they released him. So
excuse me again, I'm sorry to keep interrupting, but I want to make sure I understand everything you're telling me. What did they arrest him for in Washington?
I'm not really sure. It was a possession charge, and that's why
they don't care about marijuana up there, do they? They don't file on.
No, it was harder. Yeah.
Okay, so some kind of felony possession,
like a meth charge. Correct.
Okay.
And you guys, I let you guys know that he was in custody prior to that, but they would not recognize your warrant and put a hold on him. They tried. But my so he was booked in.
Sir,
I'm sorry.
Sir, I'm starting to lose your volume. Is there any way you could project a little louder?
Yes. So they were going to release him there again, just like they did the last time. Luckily, we were able to get in contact with your court, and somebody over there was able to send the warrant to this county, and it shows right here that on 8/28, a day later, that Greenwood County GW 24 CR 58 has been added to his list of charges there. So that was on August 28th. Now, when we had that added, when one of my agents spoke with the court, he had to be back and forth with, I don't know who it was because I was not there, but that was in order to get that hold placed so that he would not get released. And we were under the impression that since we had our hold placed and everything had been done on our end, like we had agreed upon within the amount of time, that that was going to get taken off of the docket like you guys have done before. And now I guess we had received information that were due to pay it on this last hearing. I believe it was last week. That's why I filed a motion and wanted to come personally in front of you, because I've dealt with you so many times, and anything that you've ever asked of me, I've made sure I've gotten done, you know. And I just I don't think it's fair for a misunderstanding, especially with all the loopholes and all the different crap we had to, excuse my language, all the stuff we had to jump through to even get this other county to even hold him on a felony warrant, you know? And it was an honest mistake. And if it was dropped somewhere, it wasn't anything intentional, because we would never disrespect your court ever. And that's why we're here today, is because I want to bring this to you personally, because you know you granted me 2 months instead of 30 days because we knew he was on a boat. It was a wild area, just all the circumstances, you know what I'm saying? So that's why we're here today. It's just to, hopefully you could reconsider that, because I try to please you and I want to keep you happy.
Okay. Well, before I address Miss Gillette, how did it come out with the girlfriend? I think you were going to try to do a 2-for-1 out there and catch them both.
Yeah, so hers, I need that. She actually got on, she went to court. She got on Zoom.
Showed up. Okay.
Yes.
Okay. All right. Ms. Gillette, your response to this motion to reconsider and set aside the judgment?
Your Honor, we've had lots of issues with this matter and getting this individual back here. The reason that there's a bondman and a cash surety bond is they take a chance on a person if they bond them out. And in this matter, the defendant failed to appear May 10th of 2024. There was a bench warrant and bond forfeiture, and a new bond was issued. He was arrested in Washington State, and they never notified anyone, and they let him out, and they did not serve our warrant at that time. That was in June. July 12th was the bond forfeiture bench warrant date to have them have judgment on the bond for the bondsmans. The defendant failed to appear, and there was again a no bond put on him, and he is being held, and we gave additional time from July 12th to September 13th for the defendant to be brought to Kansas and be brought before the court. On September 13th of 24, the defendant again failed to appear and did not collect his notice at the address that he gave, and the bondsmen failed to appear. Judgment was granted, and it was made a cost of the case. On September 27th of 2024, the bondsmen called my office. My staff spoke with them and he said that Webster knows him. He always zooms in. Well, he didn't zoom in on 9/13. He had received notification about the hearing. He told my staff it was an honest mistake at that time. Since then, the defendant has been located in Washington, but it's after the judgment has already been made, September 13th of 24. I don't have a defendant. I don't have the opportunity right now to extradite him or the notifications that he needs to be extradited. This is the first I've heard that there's even a hold on him. And so at this point, judgment was already granted September 13th. It was made a cost of the case. The bench warrant still stands. I want it paid. He's going to have to be transported from Washington. And the transport I had from Washington the other day was $3,900 and some dollars. Judge Ricky just issued it yesterday as restitution on a case. And $3,900 to bring that individual back to Kansas. I'm estimating it's going to be a similar amount to bring this individual back to Kansas. It's already been granted. At the time that the person was supposed to be produced, they weren't. And that is the risk that the bondsmans take when they sign on a bond, that they're going to be responsible for somebody, keep track of them and make sure they're here in court.
Can I speak? Or is...
Yes, please, go ahead.
Okay, so unfortunately, I have had him in custody since August 27th, Your Honor. That's well before the forfeiture date. Also, in order to get that hold placed on him, which I have on the computer here, it says I had to call you guys in order to get that hold placed because, unfortunately, like I said, it's such a stressful, it's illegal for me to go there to apprehend somebody. That's kidnapping. I'll go to jail for that. So you gave me the ample opportunity and time. I already spent X amount of dollars to hire somebody out to go out there and get him. And, we do this all on our own. We had him well before the forfeiture hearing. And so that's where the misunderstanding is because our forfeiture hearing was in July. You gave us until the 13th of September, and we had him in August. So,
sir, why didn't you show up at that hearing in September on the 13th?
Because when we had the court called to have it, so you know how when somebody gets put in custody, just like Dylan Philmeyer, okay? I'll just go back to the Philmeyer case. When he was in custody, it was removed from the docket once we had called the court and spoke with the court. So this was spoken with the court, and we had the hold placed on him. And we were under the impression that, okay, now the hold's placed on him. It's removed from the docket. That's the only reason why I wasn't there. I show up to most of your hearings just to make sure I'm not missing something. So it was not an intentional, that's the last thing I want to do after I spent almost $6,000 hiring a bounty hunter who wanted, I think 30% to do it. And he was the only option I had out there. I mean, I exhausted all my resources and everything I could to get this done in time. And I also had Bailey on Zoom to make sure that she made her court date instead of missing,
Is that the girlfriend, Bailey?
Yeah, that's the girlfriend, yes.
Well, on July 12th, 2024, we set that September 13th hearing, and I'm not aware of it ever being canceled. But
I don't know if this bondman is aware of his own procedures because this case bail bonds is the same one that Thomas Taylor was just logged in on.
Oh, really?
No, he's not in. No, he's not. Thomas Taylor was not logged in on mine. Thomas Taylor was there in person, ma'am.
Okay. Well,
is he the same bonding company you are?
No, I don't even know Thomas Taylor. I'm in Wichita, Kansas, Your Honor.
Okay.
Either way, there are procedures. There's no notice of incarceration elsewhere in the file. There's no motion. There's no appearance on September 13th. There's no request to be released. There's no notification of a hold. There's no anything filed in the court file. There's nothing granted to my office other than a call saying it's an honest mistake. And in that call, there wasn't even a notification of incarceration. And I let it slide a lot. There's no notices of incarceration filed in all these cases. Maybe I get meaner and not withdraw these. But when they out of state until they are in state, the bondsmen are still responsible for bringing them back. And a lot of times I change the judgment from the whole amount of the bond when someone's out of state for a judgment for the cost of retrieval and transport. And so I am still asking for the judgment. He missed the hearing date. He didn't file any of the notices. He didn't file any of the proper paperwork. He needs to go back to Bondsman school and be looking this stuff up. If he's going to be in the business, he needs to know the game. I used to represent bondsmans when I was in civil private practice. I filed the notices of incarceration, the motions to be released from bonds when people were turned in, and I represented two different bonding companies. So I understand, but he needs to go back to school if he's going to be in the game and learn how the proper procedure goes. Same as Mr. Thomas Tyler. They both need to go back, or Taylor need to go back to bondsman school and figure stuff out, because at this point he missed his hearing day. He didn't get a notice into us. He didn't do the right and proper things. We're sitting here still with no defendant, and this is the fourth failure to appear that the defendant out of state somewhere.
He's in custody out of state. He can't be brought. I could not retrieve him out of state. Like I said, I don't understand. Like I don't understand where this is at. But like I said, we had to contact your court in order to even get the hold placed on him. It was such a hassle. We've had him in custody twice out there and could not get the hold placed on him. Your court had to place the hold on him. I understand that you're frustrated, and I understand your stance on this.
I'm tired of doing say the same things, Judge. We don't defendant. He hasn't paid to have him brought back. If my sheriff has to go get him, it's going to be almost $4,000 or over.
All right. Mr. Case, do you have any idea where Washington is on their proceedings against the defendant?
I do not. I can contact them. I know that they have him held on some other stuff. It's on BindLink right now. He's still held.
Well, I have him for possession of methamphetamines, possession of cocaine, and in such a large enough amount of these drugs that he also has a felony drug dealer tax stamp charge.
See, and those are serious. And that's where I'm back to this other part of this. Okay. So I have been a bondsman for a while now, and I do know the procedures. And like I said, we are newer in your guys' area and in front of you, and your guys' procedures are a little bit different than Sedgwick County's, which I understand, and I will adapt. And I've arrested people on Zoom with you before because you've told me to. So I do everything that you ask me to. Now, I understand her frustrations, but Washington would not put, when they arrested him on their own with your NCIC warrant, they would not hold him on your NCIC warrant. They released him. That's
I recall that. That's why I was confused when I was reading your motion today. The facts seemed different than what I had recalled you had told my assistant, who I believe we ended up referring you to the sheriff or the county attorney. I recall not which one, but they're the ones that would have to get that warrant either entered or re-entered once Washington let him go. So I have some vague recollection of that and some notes to that effect. But,
and if Mr. Gillette has seen anything from the bonding class, that right there is a big issue and a big problem, because he had been arrested and in custody, and they would not stick him with the warrant. Okay, so it's kind of, I have not disrespected her or been disrespectful, but I would appreciate the same respect on both ends, because honestly, I've bent over backwards to get this thing done. I flew out there.
Well, and that has been my experience with you.
Judge, I'm tired of listening to him argue. We're late for another docket. He missed.
Well, I understand, but
he does not, sit here. He didn't do proper notice to the court file. I notice to my office. If they talked to the sheriff's office, it wasn't sent on to me, and I still don't have a
bond. I understand both sides very well. We have a $12,500 bond forfeiture at issue here, and we also have a criminal case with no defendant.
Correct.
Serious drug charges here. I am not going to rule on your motion today because I want more information about what it's going to take to get this defendant back, and whether the bondsman can get him back or whether the state's gonna have to get him back.
You know what, Your Honor? I can contact down there, and if I have to, I will have somebody pick him up and bring him back. I have no issues, but we have to figure out what the deal is, you know? It's a fully extraditable warrant, felony warrant. They've
Understood?
released, yeah, they've released
Like I
him
said,
one.
I understand completely, Mr. Case. I believe I fully understand both sides to this. And
But a motion filed yesterday, set on my docket today, also doesn't give me enough notice because I'm entitled to 7 days.
all right,
Search
okay. Well, I'm gonna set this over. How much time are you gonna need to figure out what it's gonna take to get him back here, sir?
I could have it all figured out by next Friday if that's fine. That way, that gives them, because they're kind of a screwball area to get a hold of.
Well, I'm probably gonna give you a little more than that.
Okay.
So, Missy, what looks good?
Um,
We're not in too big a hurry just yet. I mean,
We
if I-
could do it October 18th. I'd have half an hour at 1 o'clock.
October 18th, 1 o'clock. Is that available to both the bondsman and the state?
Yes, Your Honor. I will be wherever you need me to at whatever time.
All right. I'll hold this in abeyance until I see what's going on. Get more details. The defendant does not have an attorney, as I see it. I think he was gonna get his own.
he was supposed to hire his own attorney and never even hired an attorney, ran off to the state of Washington,
Right,
has not been back. So at this point, I already have a judgment that needs to be acted on. And a motion yesterday set for today, I didn't even have time to file a written answer with everything else on.
but I don't think paying the money in is going to get the defendant back any sooner. I want to get that defendant back here. And hold him accountable. Now, Miss Gillette, do you remember the status of the girlfriend? Did she?
Bailey Argyle,
Yes.
yeah, we're working on her case.
Has she gone through prelim? Is she in front of the district judge for arraignment?
She has gone through, we've had active plea negotiations.
So does she have a trial date setting then, a jury trial?
She's set for pretrial conference October 9th at 10:30 a.m. She
Okay.
attorney, we are working on her case, this guy.
So she's set for jury trial with the pretrial coming up quickly. All right, well, I wonder why anyway, strike that. That doesn't matter. All right, well, that's where we are. We're going to take this back up October 18th at 1 p.m. I